You're driving through Arkansas. Blue lights flash behind you. Your heart rate jumps. And the next few minutes could decide whether you drive away or get searched, cited, or worse. Today, we're breaking down exactly how a traffic stop works in Arkansas, what you're legally required to provide, what you don't have to do, and how police use your own words to build a case against you. This isn't anti-cop. This is pro-rights. In Arkansas, during a lawful traffic stop, you are only required to provide a valid driver's license vehicle registration proof of insurance, that's it. You are not required to answer questions like, where are you headed? Do you know why I stopped you? Have you had anything to drink? Those questions are not about safety. They're about collecting statements. The safest answer is, I choose to remain silent. Yes, if an officer orders you out of the vehicle, you must comply. This authority comes from the U.S. Supreme Court case Pennsylvania v. Mimms, which allows officers to order drivers out for officer safety. Important, comply physically, but do not consent verbally to anything else. Compliance is not consent. If you're ordered out, roll the windows up, turn the vehicle off, lock the doors, take the keys with you. Why? Because in Arkansas and everywhere else, I smell marijuana is often used as probable cause to search. Locked doors limit claims of plain smell or plain view once you're outside. This isn't being difficult. It's being defensive of your rights. Yes, you must stand or sit where the officer tells you during the stop. This is considered a temporary detention for officer safety. But remember, following positioning instructions does not mean you consent to searches or questioning. This is one of the most important questions you can ask. Am I being detained or am I free to go? If they say you're free to go, leave immediately. If they say you're being detained, stop talking. Detention requires reasonable articulable suspicion, also called RS. Let's clarify something critical. A traffic violation is reasonable articulable suspicion to stop you. But it is not RS to prolong the stop fish for unrelated crimes conduct searches without consent or probable cause. The Supreme Court made this crystal clear in Rodriguez v. United States. Once the purpose of the stop is complete, the officer must let you go unless they develop new, independent RS. That's why silence matters. Your words are how new suspicion is created. If questioning continues, ask calmly, what specific facts establish reasonable articulable suspicion of a crime? You probably won't get an answer, but you've now preserved the issue for court. Police are not there to serve and protect you in that moment. They're there to generate revenue, find violations, build cases. Everything you say can and will be used against you, never for you. If this video helped you, like, subscribe, hit the notification bell. These videos exist so people stop learning their rights after it's too late. If you want to see real-world breakdowns of police encounters, check out Audit the Audit Long Island Audit Lackluster. These channels show how the law works in reality, not theory.